Hello, and welcome to Sacred Contract. My name is Thomas Linzey. I'm Senior Legal Counsel for an organization known as the Center for Democratic and Environmental Rights. We're one of the coalition partners on the Sacred Contract project dealing with land that owns itself. You've probably ended up here because you're a title holder who's interested in exploring what this land that owns itself project means for your parcel of land. That this program has been set up for, to take privately owned parcels of land and actually transition them to this new model of land that owns itself. So this short Zoom presentation is basically focused on why do the land that owns itself? How's it different from other land conservation vehicles that folks use? And what's some of the practical steps? What does it mean for title holders to actually go through this process? So we have a short PowerPoint and going to bring that up now. And so what we're talking about essentially is building a new relationship with nature. And these are, again, emergent land ownership models that elevate the rights of nature, this concept of ecosystems having independent existence from humans and from property ownership above property rights. When we start with this quote, talks about forests having no value until it's cut down under our current economic system, and trying to understand the ecological crises that we're currently experiencing, about, kind of that as its root, about how we see nature and how we function in this society in terms of treating nature as property. So we're going to talk about that first, how land is private property under our system of law. And in the United States, of course, we've borrowed this European doctrine of land as private property, how Western legal systems treat land, and of course, the ecosystems that exist on that land as capable of being owned as private property under our system. That land is a commodity as private property. And by virtue of that commodification of land under our system of law, owners of land acquire a certain bundle of rights, is how lawyers talk about private property ownership. And they include the right to control the land, the right to exclude others. You can't come onto my land. The right to sell or lease the land, the right to use property as the title holder, the landowner, sees fit. So again, property as a commodity. And of course, that treats ecosystems and nature that exist and depend upon that property, or upon that land, as property themselves. So in the US, we have constitutional protections for landowners. Our US Constitution, kind of the source code for our system, provides certain legal protections to property owners. And these are the highest legal protections afforded by our system of law. That includes protection against taking of land. You can't have your land taken by government. Protections for land use for commercial and other business uses. In other words, that laws passed by government can only go so far, and for protecting ecosystems on land that the property owner intends to use for commercial and other business interests or business uses. And also protections against neighboring land uses that would affect your use and enjoyment of your land. And so here we're talking about, nuisance. If there's a junkyard on a piece of property that adjoins your own, there may be some ability to control what happens in terms of interfering with your use and enjoyment of your land. Those constitutional protections, unfortunately, or fortunately in some instances, constrain our environmental laws. There's only so far that environmental laws can go under our system of law without depriving property owners of their planned uses of their property. And again, generally, property ownership carries with it the right to destroy the land or right to destroy the ecosystems on that parcel of land. And because environmental laws really work within these constraints, they have generally failed to stop the kind of environmental crises that we're experiencing today. So a lot of folks who have land have attempted to preserve that land within conventional methods of land preservation. They include land conservancies, one of the most popular categories. These are nonprofit organizations that are set up to buy and hold land for preservation. And so we have a bunch of land conservancies or land trusts operating in the US, about 1,200. And you may have heard of some of these: the Nature Conservancy, American Farmland Trust, Trust for Public Land. These are all nonprofit organizations that were set up to actually purchase or receive donated land to protect or conserve for certain purposes. So like the American Farmland Trust ensures that land donated to them can be used in perpetuity for farming or agricultural purposes. So different ways of protecting, different levels of protection, but these are some of the groups that do that. There's also something called conservation easements, where if you don't want to donate your land, you can donate or sell an easement on that land. And the easement, one way to look at it is just the landowners voluntarily giving up their right to develop the land in certain ways. So an easement is a written document signed by the landowner and signed by the entity either buying the easement or receiving the easement as a donation. But think of it just as a physical piece of paper that then gets recorded with your deed. So if someone goes to the county recording office and looks for your deed, they will find the easement. And the easement basically gives a third party, or in this case, a second party, the ability to enforce certain restrictions on land use. So if you say, I want to leave this property in pristine condition, and I want somebody else to enforce that while I'm living, but also when I'm gone. So these are in perpetuity. You're essentially giving that right away. So you're destroying, in some ways, your right to develop the property. You're giving that right to an entity who has the power to enforce that lack of development on your property, both during your lifetime as well as in perpetuity for others that may own the land in the future. Why do people do this? Well, number one, they may ethically or morally want to protect the land forever in this way. And in addition, they might receive a tax benefit under the law for donating the value of the easement itself, because of course, development rights have value monetarily, and so might receive a tax benefit, tax deductible donation for donating that easement. So state governments generally define who can hold easements. There's some regulation about how you can donate or sell those easements, but that's basically the conservation easement. And again, first step is the conservancy. You can give your land or sell your land to a nonprofit conservancy. This is the way of not transferring the land, but actually signing an agreement not to develop the land in a certain way. There are certain limitations to these models. Perhaps the biggest one is that both conservancies and the easement process work within the existing property right structure. So they assume and accept that land is a commodity and work within that structure. In addition, generally, you can't control through these vehicles what happens on adjoining land that may affect the conservation value of the land that's within the conservancy or the easement. And they generally only allow the easement holder or the conservancy itself to enforce the protection of the land. So no third parties like environmental organizations or people living in the community can enforce these covenants, these easements, or sales, but only the parties can. And so basically, these are the vehicles created within the existing property right structure. They accept that nature is property, that land is property, and accept those constitutional and other legal constraints that come with that. But they work within that structure to try to protect land. So there's been a couple new models of protecting land that have emerged over the past 10 years. And so there's basically two that we work with. And the Sacred Contract is committed to scaling. And they're built around two concepts. One is rights of nature easements. Their laws have been passed around the globe, including in the U.S. 36 laws in the U.S., including by the city of Pittsburgh, Pennsylvania, and county of Orange County, Florida, that recognize that nature has rights, certain kinds of legally enforceable rights, like the right to exist. So a river having a right to exist, a river having the right to flow, a river having the right to flourish. Basically, constitutional type standards that recognize that nature is capable of possessing rights. So the way we usually explain it is human rights type protections for ecosystems or nature. Those ecosystem rights have been built into conventional easements. So again, we have conservation easements, typical conventional way to preserve, protect land. We've taken those easements and supercharged them with this rights of nature language so that landowners can create or recognize rights within their community, on their land without passing a law. So can do it privately through these easements that recognize nature's rights within those easements. So again, taking conventional conservation easements and then kind of supercharging them with this rights of nature concept and language. And then the what we're here to talk about today mostly is about the land that owns itself. That there's a pioneering model out there beyond rights of nature easements and beyond rights of nature, in which a land can own itself, basically be autonomous or self-owned. Some people refer to it as land sovereignty or land back to nature, even. But new models of land protection are emerging in these two areas. So this is some detail about what these rights of nature easements do. And again, they're built on top of these conventional easements that have been used for upwards of 40 or 50 years in the US. They create legally enforceable rights of ecosystems within the framework of a conventional conservation easement. Builds on language that's developed through these rights of nature laws that have now been passed in at some level or another in about 12 countries around the world. They make nature itself a party to the easement in some places so that ecosystems can enforce protections themselves. In these rights of nature laws that have been passed in various places, the plaintiff in enforcement cases to enforce those rights to exist and flourish and flow and be healthy and right to clean air and clean water are actually enforced by the ecosystems themselves as a plaintiff. And they also provide enforcement authority to any party, in most cases, with an interest in protecting ecosystems. So expanding the body or number of people that can enforce the easement constraints. And probably the most important part, at least on paper, that these are enforceable against development and activities outside of the land parcel. When you're dealing with rights, rights can't be constrained within certain boundaries. And so if something's happening outside that parcel of land that may interfere with the rights that have been established by the easement, there's a way to enforce those rights against those activities happening outside the parcel. And again, this is the limitation of conventional easements, that you can't enforce them outside the parcel because they are not rights-based. So the example we use here is a stream ecosystem on the parcel having a right to flourish. You have mineral extraction, coal mining or something happening upstream that's affecting that right. And then there's an opportunity to enforce those easement protections against the extraction upstream to try to stop it because it's violating the rights of the stream ecosystem as it flows through that parcel of land that's protected. So again, takeaway here, don't get lost in the details. This is taking conventional easements, which have been around for a long time, conventional conservation easements, and basically adding this component to them to make them more effective and make them more enforceable. So that's the takeaway here for these rights of nature easements. These are some of the specific steps. It includes drafting the easement, which can be fairly complex, 30 or 40 pages. But the easement details out how the title holder wants to see the land used or not used into perpetuity. And so that's what you cement into the easement itself. And then, of course, the easement contains prohibitions, how the land can't be used, what can't be done on the land, and then enforcement information about how to enforce them, who can enforce them, those types of things, along with baseline data about what the property looks like now, how it's functioning, and then determining an appropriate organization who can hold the easement, and then signing and recording the easement with the deed. That's so that everybody knows that it's happened. And anybody looking at your deed knows that there's a rights of nature easement on the deed. So they can obtain the easement agreement through that attachment to the deed at the recording office. Rights of nature, of course, this concept of conservation easements having rights of nature components in them, traceable back, as well as the rights of nature laws, traceable back to indigenous understandings of nature as not being property. So this concept of nature being able to hold or possess rights is basically a evolution transition of a Western culture from treating nature as property to this indigenous understanding of nature as not being property. First Nations, of course, treat nature as something that can't be owned. and they speak about nature as a living being or as a relative. So much different approach, but basically driving these indigenous value systems into this Western system of law. So that brings us to the, kind of what that context gives us is this new land that owns itself model, which we usually refer to as beyond rights of nature. So moving beyond those rights of nature easements into this concept of land that owns itself. What does this mean? It basically means creating a legal mechanism for ecosystems to own themselves. What does that mean? Well, it means creating a legal alter ego for the land. So a legal structure that is a mirror or an alter ego of, or an avatar of the land itself. So that the Western system of law that we have, you're actually embedding that legal alter ego into that system of law. One way to look at it is it's a representation of the land. And the way that we accomplish that is taking the ecosystems that exist on the land, joining them together, and it's that association of those ecosystems coming together that becomes an alter ego or avatar of the land itself. So most times when you have these associations that are formed in law, they're human beings coming together to form those associations. They're the associators in the name of the law or lingo of the law. But here we're talking about the ecosystems, like the climate ecosystem, the water ecosystem, the flora ecosystem, the fauna ecosystem, as those ecosystems becoming the parties who join as associators in this association to give it a legal presence in the system of law. So a representation of the land in the law as an association of these ecosystems coming together. That's the purest form of what this means. And then because those ecosystems can't speak for themselves, at least in ways that Western culture recognizes or Western law recognizes, that human guardians are selected who serve as the voice of those ecosystems. And so there's the legal representation, the legal entity that's created by these ecosystems coming together can be seen by the law in a piece of paper, physical reality, of a piece of paper that is an articles of association, which basically just outline the rules under which this legal entity is going to function. And in that it binds these guardians and trustees in certain ways, like to act in the best interest of the ecosystem, et cetera, that these guardians come into a system in which they're the voice of these ecosystems, but the underlying associators, the underlying pieces of that association are actually the ecosystems themselves. The guardians are just a voice for them when they need to act within this Western system of law. And then the final act, of course, after this entity is set up, is that the deed for the parcel of land transfers to that entity, so that the legal entity that is a representative of these ecosystems physically owns the title to the land, thus accomplishing the end goal of land that owns itself because it holds its own title under this system of law. So again, alter ego for the land consisting of the ecosystems having a voice through the guardians and trustees, those guardians and trustees being bound to act in the best interest of the ecosystem. And then the actual physical title, the deed, is transferred from the property owner entirely to that alter ego entity of the ecosystems, represented in voice at least by the guardian. And again, we just covered this, but the formation of the legal entity is through something called articles of association. So the legal entity is what's known in the law as an unincorporated association. And it's that articles of association that contain provisions recognizing that ecosystems have certain rights, ecosystems are no longer considered property, and a legal mechanism for both selection of those human guardians as a voice of those ecosystems, as well as provisions for secession of those human guardians. So who takes those seats as the guardians either resign or die or move into other lines of succession? How do you guarantee that these associations will continue in perpetuity to look out for the best interests of these parcels? And so that's what the articles of association do. But the takeaway here again, alter ego for the land, a representation of the ecosystems that come together as associators to associate with each other in the law to create this unincorporated association. And those ecosystems within the unincorporated association then have voices that are represented by the guardians or trustees who are bound to do certain things in the best interest of the ecosystems, make decisions in the best interest of the ecosystem. And it's that entity, that unincorporated association, that eventually holds the title for the land. So again, land that owns itself, that's kind of the nitty-gritty of the process. We also, because we like more enforcers for protection of the land than less, we, in at least the first pilot project and the other projects that are underway now, that we use a rights of nature easement prior to the transfer of the deed to that alter ego. So we create another level of protection before the land physically transfers, the title transfers, which recognizes and protects rights of nature on the parcel. The reason for that is to create a third entity or another entity that has the legal authority to enforce the restrictions on development on the land. So in addition to the human guardians who are guardians and trustees for the ecosystems in the unincorporated association, we in essence give away the right to develop the land prior to that title transfer happening to a nonprofit entity that also has the responsibility to protect the ecosystems on that particular parcel of land. So again, creating various levels of responsibilities and constraints to make sure that even if one level of that protection system goes awry for some reason, that there are multiple levels of safeguards and enforcements in this process to make sure that the land is perpetually protected. And so rights of nature easement first, then the transfer of the land to the unincorporated association that's created as the legal alter ego. And I know a lot of this is like drinking from a fire hose, but this is kind of like the high level overview of what the land that owns itself project is about and how it's used in practical purposes in conjunction with one of these rights of nature easements to give the maximum amount of protection for the land. There are a couple pilot projects that we've been working on. The first one was completed in August of 2023, and it was in Washington State. This was a proof of concept, in essence, to say this can be done under US law. And it involved a couple of acres in Washington State, forest land that was owned, that the title holder wanted to shift into this land that owns itself project. And it's the steps were that the property that the title holder signed a conservation easement to protect the land that contained rights of nature provisions in it, then transferred the title to the unincorporated association of the ecosystems that exist on that property, and then on that land, and then the title was recorded in the county recording office successfully. And so the Washington State pilot project successfully completed in August of 2023. Sacred Contract is working on a cohort of other projects to begin to scale up this concept of land that owns itself. It's also a project we work on in Nova Scotia, some old growth forest that the title holders want to transfer over into this land that owns itself concept. But again, takeaway here is has been done under US law, kind of to prove that it can be done under US law in terms, especially in terms of this unincorporated association holding title to the land, and the unincorporated association being comprised of those ecosystems themselves. But that's kind of the overview of the process that you're looking at here as a title holder. And again, this short introduction is not intended to be an exhaustive exploration of this land that owns itself project. The Sacred Contract is available to have individual conversations and meetings with title holders about what this looks like specifically for your parcel, for your land. But that's the overview of what the project is and the various steps. So for our part, as part of Sacred Contract, the Center for Democratic and Environmental Rights, this is our webpage at the bottom, our contact information as well. We have a program area identified for the Land That Owns Itself project that has some background reading on it as well. And in addition to that, Sacred Contract has provided you with a packet of materials, which include frequently asked questions, a welcome letter, other things that may serve to answer some of the questions that you inevitably have. But feel free to contact Sacred Contract or ourselves directly if you have questions about any specifics dealing with this project area. So again, big takeaway. Number one, we have a system of law that doesn't really recognize nature at all. Number two, for those title holders, landowners that have wanted to protect their land permanently under this system of law that we have used land conservancies and traditional conservation easements to do so. Three, however, those vehicles have certain shortcomings. Four, there are new emerging models that try to fix those shortcomings and recognize that nature has rights and that nature itself and ecosystems are not property. Five, there is this new project that's arisen called the Land That Owns Itself, which allows under this system of law creatively for the title to the land actually to be held by the ecosystems on that particular parcel of land itself, and for that process to exist under this system of law in terms of being a real land transfer, title transfer to the ecosystems, thus accomplishing this land that owns itself. So thank you for exploring this with us today. And again, we're on hand to answer questions. And thanks for being a part or thinking about being a part of this sacred project or Sacred Contract project. Thank you.